Hi, my name's Evan Nielsen from Nielsen Law Group. Thanks for joining us. I was going to cover just briefly in this video segment the bankruptcy process in general. It begins, obviously, with the decision that you need to file bankruptcy, but when you initiate that, the first step will be filing the bankruptcy petition. Sounds much simpler than it is. It's usually a 40 to 50 page document with a substantial amount of details about the financial information currently in your life, and it also has to include all of your assets and all of your liabilities. Once that gets filed, that begins the process. There are a number of things that happen at that point. The first one, and perhaps the most important, is that the court orders a stay or a stand down time for all of the creditors at that point. So from that moment forward, until notified otherwise, all creditors have to stop any collection activity or communication with you relative to the debt. And that can only change if they get the court to lift the stay or once the discharge is entered. So the next step then would be the court will identify a trustee to manage the process, and that bankruptcy trustee will call a 341 meeting, or a meeting of the creditors. That's a meeting that you attend with your attorney. The trustee will have reviewed your petition. They'll discuss it very briefly with you, and they'll also ask you to, under oath, indicate that it's accurate. A 341 meeting usually lasts between 3 and 5 minutes. They're not very long. They're less formal than a court setting, and there'll be a time for the trustee to review your specific information with you. The next step, after the trustee has reviewed the information and the 341 meeting has been held, the trustee will evaluate assets and determine whether or not there are any that need to be liquidated, and then issue a report. And in many cases, in a Chapter 7 bankruptcy, it will be a no asset case. So the trustee will just indicate there is nothing to liquidate. If there is, that will be reflected in the report as well, and that'll be filed with the court. Once that occurs, creditors are given a period of time to respond, usually 60 days. After that period has expired, then if there are no objections to the report, then the motion to discharge the debts will be entered, and the court will grant that motion, and you'll receive a notice that all of those debts have been discharged. That formally completes your involvement in the bankruptcy process. It's possible that the case may still be active on the court's calendar for some time, but that's simply because the court has not gotten around to closing the case. The discharge is what matters, and that's when your debts are actually discharged. The whole process usually takes between 4 and 6 months. In some cases, that can be longer. It's rare that it's any shorter than 4 months. Now, there are other details about the process that would potentially change depending on your specific circumstances, so you'll want to discuss those with your legal advisor. But I hope that's been helpful. If you have questions, we'd be glad to visit with you about it. Feel free to call us. We wish you the best. Thanks.